Honorable Court of Criminal Appeals of Tennessee is now in session.
All right, thank you. This is the March term of the Court of Criminal Appeals from the Western Section of Tennessee. The panel today, who will be situated to my right, is Judge Tim Easter from Williamson County. And to my left will be Judge Ross Dyer from the Shelby County. I am Kerwood Witt. I come from Monroe County. And you may call our case, please, ma'am.
State of Tennessee versus William Gossett.
Thank you. Arguments are 20 minutes per side. If you, as the attorney for the appellant, wishes to reserve a portion of that 20 minutes, please make an announcement to that effect at the beginning of your argument. And you may go ahead.
Good morning. Thank you, Your Honor. I would like to reserve 3 minutes for rebuttal argument.
How many?
3. That is 3.
Minutes. Very well. Thank you.
Thank you. Good morning. My name is Joe McCluskey from Shelby County on this case, representing Mr. William Gossett from this case out of Shelby County. We are here today on this appeal on one very extremely narrow issue, whether or not Mr. Gossett was properly sentenced as a Range 2 and Range 3 offender in these cases. We are not appealing whether or not he was properly sentenced to consecutive sentences or whether or not these were properly sentenced to the maximum end. The record, I think, establishes that that was proper in this situation. This is a case that involves 12 separate indictments of home invasions and sexual assaults on various women. It's a very, very troubling case. Unfortunately, Mr. Gossett also had, prior to committing these offenses, he had a criminal history from when he was a juvenile. And that's what we're addressing in this case, is how that criminal history should have been used to enhance his sentence. The court found that his 2 prior convictions for rape of a child from the late 90s should have been counted as multiple convictions. The court below found that they were violent offenses, and for that reason would count as multiple convictions. Therefore, the court sentenced him as a Range 2 and a Range 3 offender on all of these various crimes in this situation. My argument today is that because those 2 rape of a child convictions factually occurred on the same day within a 24-hour period, and because rape of a child does not include among its statutory elements any level of bodily injury, that 4035-106B4 and 4035-107B4 both would indicate that for the purposes of sentencing and determining range, those 2 convictions should be considered one conviction for that extremely limited purpose. Any other information, of course, found out of that could be used to enhance within those ranges, but for simply determining the range, we should only be counting that as one conviction.
Mr. McCluskey, let me ask you this before we, maybe I read it wrong, but let's assume your argument is correct and that was one criminal episode in juvenile court. Wasn't there sufficient other evidence to sentence him within Range 2 and Range 3?
I think the only evidence was that he had these 2 prior convictions. I think these should be considered one conviction. I don't think there would be any other evidence to enhance his range.
Right.
Now, to enhance within a range, I think there is ample evidence to enhance him, as the court did here, to maximums and consecutive sentences. I think there is ample evidence of that. I think the juvenile court matters brought in additional information as well that could enhance within a range, but I don't think it should be allowed to enhance outside of that range.
Well, could not these events themselves, these 12 indictments, been used to enhance him to a 2 or 3?
I don't think these 12, I think with that situation, because these are all indictments he pled to at a single time, obviously they're not prior convictions at that point. So I don't think
Okay.
that could be considered by 4035-106
Okay.
prior, because they're what's in consideration now.
So it all hinges on these two juvenile
Yes, Your Honor. Yes.
convictions that got him to range 2 or range 3.
Correct.
Okay.
And then obviously rape of a child, 4035-106 requires, in order to establish multiple convictions as remaining multiple convictions, it requires that elements include bodily injury, serious bodily injury, or the threat of one of those two. Obviously, rape of a child does not include that, any element of bodily injury. The Tennessee
There seems to be, is there not case law out there where the court has said that inherent in rape is some sort of, there is an injury, there is bodily injury inherent in rape?
Sure, and there is some case law that says that. That is mostly in concerning, as it concerns enhancement and mitigation factors. So I know the state cited numerous cases where you cannot get a mitigation for saying, hey, there was no serious bodily injury in this rape. Well, they say, well, hey, there's an element of injury in all rapes. And yeah, that's true. But what 4035-106 and 107 require are statutory elements. Statutory elements, not simply that it involves that. Involving that, I think, is why it can be used to enhance within the range, but it can't be used to enhance the range itself.
Let me ask you one more question about, so as I understand from reading the briefs, the two juvenile offenses, it wasn't like it was just, in reality, it wasn't like it was just one rape of each victim. It was a series of rapes over a period of time. And how did the juvenile court deal with it so that you get it to one date? That's what I was a little confused about, because I think it was very clear from the proof he raped these or molested or whatever, touched whatever different varying things over a series of time, but they came down to one date. Could you explain that to me a little bit better?
I cannot completely answer that. That is a problem with the way the juvenile record is transmitted from the juvenile court to the criminal court. We don't have any information other than what's there. Apparently, all of the parties and what I read in the record indicated that it stemmed from the Christmas Day episode, is my understanding of what brought those crimes about. I think there was one of those young victims said it only happened the one time. The other victim said it happened over a period. Be that as it may, rape of a child is not a continuous offense. It is a single discrete offense. So while the juvenile record does indicate there were multiple acts, for the purposes of 4035-106, there is one conviction, or two convictions in this case, of each of the children. So multiple acts that were alleged didn't result in a conviction. So
you're saying, I recognize that the record's a little unclear, but basically your argument is that in juvenile court, they did the equivalent of a bill of particulars that we do in criminal court, and just said, for child A, we're electing the incident on Christmas. While there may be other incidents she testifies to, we're going to, quote, trial, we're submitting to the jury, if we were in criminal court, this date, as opposed to anything else that may come up.
Yes, that's my understanding of what happened. And I mean, you can't have a rape of a child that happened over a 2-year period. It has to be just one occasion. It's not a continuous offense, and you don't get to have that 2-year period on it. That's not how convictions for discrete acts in Tennessee work. So I think it would be improper to do that here, to allow that kind of long range crime when it's never been done before. And there is case law, of course, that kind of suggests that. I think the State versus Phillips, I think, indicates that rape is generally not a continuous offense. You would just look at one discrete event. And again, all of that other stuff that came up in the juvenile case, I think all of that could be used to enhance within the range. But for our purposes, we're just looking at a conviction. And what we have to look at is just that one conviction and how to treat it. I think also when we start trying to suggest that multiple crimes should be treated differently, we start to come into the single course of conduct theory, which has been soundly rejected by courts numerous times. So I think we do need to make sure we're not straying into that single course of conduct theory, and get away from that. So again, there's the elements of this offense that we're talking about here don't require the bodily injury. And then whether or not it was in the 24-hour period, of course, I think the record is somewhat unclear on that point. I think if anything, maybe we could remand, if that needs clarification, remand for a more clear juvenile record on what exactly the adjudications are. But be that as it may, I think I've laid out my argument as pretty much I laid it out in my brief. If the court has no further questions, I'll relinquish.
Let me ask you, you're not saying that 4035-106 or 4035-107, which define multiple and persistent offender, range 2, range 3, it does not exclude juvenile adjudications. I mean, it's clearly there. A sentencing court can consider juvenile adjudications.
Right. I believe that juvenile adjudications can be considered. I think just the question we have is whether or not these should be considered 2 or 1, whether or not it's a crime involving bodily injury that occurred within the 24-hour period and that. But I do think the juvenile considerations can come in.
And there were how many convictions or adjudications in juvenile court?
2 adjudications.
2 different victims?
2 different victims. That my reading of the record indicates that it's from an event that occurred on the Christmas Day event. And if there are no further questions, I would ask the court to reverse the sentence and remand for further sentencing.
Thank you. General?
Good morning. My name is Andrew Coulomb. May it please the court here on behalf of the state of Tennessee. I guess, Judge Easter, to start off with your question, yes, the juvenile convictions, if they would constitute Class A felonies, are considered for range purposes, and rape of a child is a Class A felony. So they would be considered here to establish range. And so then there were basically 2 counts. One, did he rape the boy, and one, did he rape the girl? And this kind of gets to your questioning, Judge Dyer, of, all right, well, what was alleged, what was shown, and what did the juvenile court do? And you'll find these in volume 2. If you're looking at it through like a Adobe Acrobat with a PDF, it'll be on pages 43 and 47 of that volume. Is where the pertinent pages are. So he was alleged generally to have raped the boy and raped the girl. The girl, it said he abused the girl in some fashion in 1998, culminating in raping her on Christmas Day, December 25th, 1998. The boy alleged, and that was alleged in the petition or the complaint, that the defendant had begun raping him in 1997 and then repeatedly raped him throughout 1998, also again ending out on Christmas Day, 1998. So these are the allegations, that there were repeated rapes in 1998 of the boy, and there's at least one rape of the girl on Christmas Day, 1998. So those are the allegations. That is what we have. And what we have also is in the record is that this petition was sustained. So there was a finding beyond a reasonable doubt that these allegations were true, and he was found to be delinquent. So if this were an adult case, if this were in criminal court, then we would have unanimity problems, right? Then the question is, okay, we have this proof that's come in that he has repeatedly raped the boy throughout 1998. State, now at the end of your proof, please elect one of these so that we have a jury trial, make sure not one juror isn't selecting one of the rapes, another juror is selecting another rape. Are we all on the same page about which rape we're talking about? There has to be an election. But this isn't a jury trial. This was not a trial in adult court. This was a juvenile delinquency adjudication. with a judge, so a single judge. There was no need to elect. There was no unanimity issue in present. So it wasn't for the judge to say, okay, I'm going to pick out which one of these, or it wasn't for the state to say, I'm going to pick out which one of these I'm actually going to rely on. The state basically, the proof was he repeatedly raped him for over a year. And the court said, I agree with you that I find that credible, and I agree with that beyond a reasonable doubt. So I do find that he raped the boy, and I do find he also raped the girl. What the defendant is asking this court to do 22 years later is to essentially make an election. Is to simply say, okay, well, let's just choose one of those dates and ignore all the rest of the dates, even though from what we can see in this record, the juvenile court found these allegations credible, sustained the petition. That's what we have. It sustained the petition. And say, ignore all the rest of the things. It said he raped the boy repeatedly for over a year, for months, certainly more than 24 hours, longer than before than he raped the girl. Ignore all that. We're going to choose one date. And we're just going to choose the one date that happens to be the same date he raped the girl. And from that, now the 24-hour merger rule comes into play. But the state respectfully submits that the court shouldn't do that. That is not the proof that came in. That is not what the juvenile court did. And that the criminal conduct that was found to have happened was not limited just to that one 24-hour period. We're not saying this is a continuous offense. We're not saying that rape of a child is one continuous offense that lasts for a year. We're not arguing that. What we're saying is there were repeated basically rapes of a child that went on that were alleged. And since there was no need to elect, all it was before the juvenile court was to find, was it credible that he raped this child at some point during that year? And it found that he did. And that's what we have. If there was suggestion we should remand to get more clarification what happened in the juvenile court. Respectfully, if that was a real problem, that should have come up in the trial court. And it didn't. And there's a reason for that. And that's because the defendant never challenged the range in the trial court, never said this range was wrong, never said the juvenile court record means something different from what we're saying today. The defendant seemed content with the range 3, certainly never objected to the elevated ranges. So it is a little strange to suggest now on appeal that, well, maybe this isn't what we think it is. Let's go back and get some clarification when people seemed content with what that said then. In any case, what we have again here is criminal conduct that was found to extend more than beyond a 24-hour period. And that is and the 24-hour merger rule is confined to, when the criminal conduct is confined just to the 24-hour period, we have findings of guilt beyond the 24-hour period. Because of that, the 24-hour merger rule does not apply, because that there were 2 Class A felonies, what would be Class A felonies, the rapes of a child. That is enough to elevate the ranges as we had from range 3 or range 2 in these cases.
Am I understanding you correctly? Are you saying that there's no objection during the sentencing hearing as to the ranges?
That's correct. That's first raised on appeal. So, if he's saying there's some confusion about it, that should have been hashed out in the trial court, not here.
Are you suggesting that constitutes a waiver?
That might constitute a waiver. That is, I've seen some case law that suggests that. I've seen other case law that says it's a sentencing issue, so maybe perhaps it's not waived. It's a little mixed. I'm proceeding along just suggesting the court, should the court decide to do plenary review, should the court say, let's look at this straight on, we say that's still fine because this conduct extended beyond the 24-hour period.
Well, if it wasn't objected to, I guess this is what your argument is now that I'm all putting it together. But if it wasn't objected to, then the record's not really going to help us out a whole lot as to how the trial court worked through this, then, is it?
Well, the trial court made some findings and said the district attorney said we have these 2 prior these 2 prior counts of rape of a child from the juvenile court, we suggest this elevates the ranges up as happened. And the trial court looked at it and agreed and said, yep, we have findings that this criminal conduct happened, for over a year, maybe up to 2 years, depending, and said, yes, we have the rapes of a child, including the rapes of the child on Christmas Day, 1998. So I agree that we need to elevate these, or the ranges up. And I think the court did mention something about the rape of a child being a dangerous offense. So I think that was in there too. So we do have the trial court's reasoning about why it did what it did. That is there. But there was no objection to it. That was the state said, we think this is the way it should be. And the court looked at it and said, I agree. That seems to be right. And the defense counsel didn't say anything, raised no objection to it. So that's where we are. We have the juvenile court records. We have that the allegation was this conduct extended beyond 24 hours. And that was found to be credible, and that petition was sustained. So the state submits just right there. The 24-hour rule does not come into play at all. That we're not in the 24-hour merger rule. As we've laid out in our brief, if the court should disagree with that, then we can look to see whether the exception to the 24-hour merger rule would apply. And there are lots of cases out there which say that rape, including rape of a child, inherently is baked into it, basically, at least threat of bodily injury, at the very least. That need not be proven. That is simply there. And so the state also would submit that would allow the court to say, well, there would be an exception to the 24-hour merger rule. That you don't need to prove it. It's baked into the statute. It's right there. That there's at least threat of bodily injury, which is enough to trigger the
But it's not a statutory element.
That's true. It is true. It is not written. There is not a written into the statute. Doesn't
the statute that you're relying on say that it has to be a statutory element of the crime?
It says for which the statutory elements include. That's true. It does say that. Though the state would still submit that what that is getting to is you don't need to show that it was proven. You don't need to show, was there actually threat of bodily harm? Was there actually bodily harm? It was that, it's baked into the offense. And we have case after case after case after case, which says, yes, this is baked into the offense. There is a threat of bodily harm.
Are those cases for enhancement or for range purposes?
For enhancement. And we have no cases cited by either side, well, except for perhaps one, that addressed this specifically for the enhancement of the range, in talking about the range. The one case that does talk about that is a Court of Appeals case that was decided by Judge Koch, later to be Justice Koch. And that was the Mitchell case. And he said that the 24-hour merger rule does not apply in this type of instance. So that's the one case that's addressed it straight on. The other cases all talk about enhancement factors and mitigation factors. And he cited cases that talk about that, and I've cited cases that talk about it.
And you said that was an opinion by Justice Koch?
Yes, though he was on the Court of Appeals at the time. So he was then Judge Koch. But yes, future Justice Koch.
Was there an appeal from a juvenile court? Or it's in the Court of Appeals kind of causes me to scratch my head.
Yes, I would have preferred if it had been from this court. I'm forgetting off the top of my head how they got there in the Mitchell case, and I apologize. Okay. It's just popped out of my head. But it was certainly not an appeal of a criminal sentence at that point. So it was not in the Court of Criminal Appeals. It was something. It was in the Court of Appeals sphere, and this issue came up, and that's in the Court of Appeals. Judge Koch said, no, that 24-hour merger rule does not apply under these circumstances. So that's okay. So that's the only case we have that really talks about it straight on. The rest of them do talk about enhancement or about mitigating or enhancing within range. Nonetheless, the state respectfully submit, at least for this, that since it's baked in, everyone agrees that there is inherently a threat of bodily injury for rape of a child. It just is that exception should apply. But again, we only get there if the 24-hour merger rule is applicable at all. And that's only if the criminal conduct is forcibly confined within the 24 hours. And that is not what the juvenile court found. The juvenile court sustained the petition, the allegations that he had been raping this boy for over a year. And so we have the rape of a child that happened before the Christmas day. And we shouldn't elect 22 years later and say, we're going to forget all those rapes, and we're just going to say, we're going to choose this one, just this one, and say, okay, and that one happens to be the same 24 hours that the girl was raped. So now we get to merge those two under the rule. And we'd say that shouldn't be the case.
Do you agree with the defense counsel's statement that the only way that the sentencing court could have gotten to range 2 or 3 was with these 2 prior juvenile adjudications?
I agree with that. That there were, since he pled to all of these offenses, even though they occurred over a 4-year period of time, even since he pled to them all at the same time, I don't think they would be prior convictions.
Okay.
Prior offenses, but not prior convictions. So I believe that is right. That we have to rely on the juvenile findings, juvenile adjudication to reach that.
And of course, this is only going to affect his release eligibility date, correct? I mean, at the end of the day, that's all this is about, is what his dread date will be.
Well, yeah, I mean, it would affect it would affect, I think, yeah, I guess when he'd be released. He would be serving prison time either way, but it depends on what each of the effective sentences in each indictment would be. If it goes from range 3 down to range 2, for example, or range 2 to range 1, so you could lower the year numbers for each one of those.
Okay, so it'd be both the sentence length as well as release eligibility date.
Yes, yeah, the length would change by this, because you'd be moving down ranges if you found against the state here. But if there are no further questions, the state respectfully requests that the judgment of the trial court here be affirmed.
All right, thank you. Mr. McCluskey.
Thank you, Your Honor. Just very briefly, Judge Easter, I did just want to take a moment to respond to that question you were just asking about how this would affect, basically just his release. And essentially, yes, we're just talking about affecting when he would get out. The interesting thing about this situation is, regardless of what the court does with this case, this man is not leaving prison. His sentence is hundreds of years long in this situation. Even if we cut it in half, it'll still be hundreds of years long. So this isn't a situation where if the sentence as it is disturbed, he'll suddenly be allowed to go home soon. He's never going home. And even with reductions in the ranges, he's never going home.
But it will be used in the future for the way a sentencing court looks at juvenile adjudications.
That is correct. That is correct. But for the purposes of just considering how it affects this man, he's where he is. The state made an interesting comment about the element of bodily injury. The state said it need not be proven. You just can't use it. It's baked into it. The fact that it need not be proven, I think, is what is ultimately dispositive. They need not be proven because they're not elements of the offense. Because they're not elements of the offense, they should not be used for determining, if it's if with there being not elements of the offense, it should not be used to determine whether or not it's multiple offenses. I would also point out that, as this court decided in State versus Phillips, in determining whether or not something is a continuous offense or if it should be treated as just a multiple discrete offenses, they say look at whether or not each requires its own proof, timeline, location, etc. The state very eloquently today is arguing that we should view all of the rapes that occurred between 1997 and 1998. We should consider all of that multiple rapes within that one conviction. Even though the juvenile court made one adjudication, it cannot and does not encompass all of those events. Those are discrete events, discrete crimes that occurred, not a continuous.
But we don't know which day. So yes, so he made one the juvenile court made one adjudication for the male victim. We don't know which day he made that adjudication based on. Is that correct?
That's correct, but the information we have from juvenile court is there was only ever one specific date given for each of these individuals. Both of them gave the specific date of Christmas. There was no other individual date given for a second adjudication. So I don't even know if, with the level of proof here, he raped me at some point, but we don't know when. I don't know that that would ever stand any level of scrutiny to hold up a conviction on that, or an adjudication, whether or not it's a juvenile court adjudication or an adult adjudication through a jury trial.
But we're not reviewing that. I mean, all we're looking is if these are two separate offenses. We're not making a determination of whether they put on enough proof at juvenile court to determine that he was raped on, November 1st of 98 or 97, whatever the year is. We're just saying the court found at some point that young man was raped by the defendant.
And I think for it to be considered two offenses, the lower court or this court has to determine that they didn't occur within the same 24-hour period.
Okay.
And I think that the record indicates that these offenses did occur within the same 24-hour period.
Okay.
And if there are no further questions, I would ask the court to reverse this sentence and remand for new sentencing.
All right, thank you. And that concludes their argument in this case today. And the court thanks counsel for participating in the presentation this morning.
This court is now in recess.